Hi everyone, welcome to the online lecture for the Interstate Commerce Clause. This is a little bit weird. I'm sitting in my office talking to a computer all by myself. I had intended to try to use this as a way of getting some other folks to ask questions for me so this would be more dynamic, but of course ran out of time, and so we're going to do it this way. Also, just for your information, I'm going to be uploading these to YouTube, which means that for the purposes of YouTube licensing, I'll be doing this lecture in 15-minute increments. And I don't think it will take the entire class period because there's going to be some work that you'll be doing throughout the lecture in terms of answering questions, and so there'll be time for you to do some of that. Anyway, you can see the PowerPoint, I believe, if you're watching the video, and we're going to go through it a little bit by bit. It's not a very exciting one, but it gets us through the material, starting with, of course, the Constitution. So let me get started here by putting on the PowerPoint. Interstate commerce. I've been foreshadowing this all semester. I think it's one of the more exciting parts of the Constitution, and of course I'm really sad that I can't be here in class to talk about it with you. But as you know, we're going to be redoing a little bit of the class time so that we'll have at least some time to talk about it together in class, and you can ask questions both about what you're seeing on this PowerPoint, what you're reading in the book, as well as anything that you might have in terms of questions about interstate commerce. It is, I think, one of the least known and most important parts of the U.S. Constitution. Much of what Congress does is done under the guise of regulating interstate commerce, and as you can see from what we'll talk about in this particular lecture and throughout this chapter, it has gone from a relatively regulated view, a very sort of limited view, to a very, very expansive view. Right now you could argue that we're swinging back towards trying to put some curbs on how we understand interstate commerce, but clearly not in the way that it might have originally been understood, or certainly was understood at different points in American history. But for the most part, people don't understand that the way that Congress gains its power and tries to regulate for all sorts of different things is through interstate commerce. So it's a pretty important thing to know, and it's a pretty important way that Congress uses its power. Which brings us, of course, to the U.S. Constitution. Article 1, Section 8, one of our favorite clauses, right, of the Constitution. Specifically in this case, we are looking at the phrase, Congress shall have the power, right? That's what gives it an enumerated power. And then, of course, some of what we'll be talking about may be implied powers as well. But Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So if you're putting on your constitutional interpretation hats, which I know you all are, there are some words here that need a little bit more definition. I'm guessing you can figure out what they are even without looking at the question below, but question number 1 is going to ask you, and you need to take some time to do this because I expect to have an assignment at the end with all of these questions answered on it. Put in your own words what these mean. What does this power allow Congress to do? And to answer that, you have to figure out what some of these words mean. So for example, what is commerce? Where does commerce start? What's included in commerce? Is it just buying and selling things? Is it transporting goods? Is it navigation? Is it manufacture? Is it labor relations? All of these things could potentially be commerce. So what do you suppose it means to regulate commerce? Which of course brings us to that second question. What does it mean to regulate commerce? And so again, what's a regulation? Is that something that Congress would do? Does it include labor practices? Does it include health and welfare benefits? Does it include simply the transportation of goods? And then finally, among. So this sort of gives us the distinction. We have interstate commerce, which is generally how this is understood, that Congress will have the power to regulate commerce among the separate states, so that means it has to leave a state. But what does that mean about what's happening inside the state? Is there some sort of way in which we must regulate differently or not regulate at all if we're dealing with intrastate commerce? So Article 1, Section 8 sets out the beginnings of how we might understand interstate commerce. But as you know, at this point, nothing is ever that easy. Let's look at the first case. This is Gibbons versus Ogden in 1824. Like many of the other early cases, much of what happens here is trying to figure out sort of the first principles. What will be the relationship of the federal government in terms of the state? How will we look at these issues of commerce? Now, one of the sort of standard ways you might understand commerce is to say it's the buying and selling of goods. Question then is, what happens when you have a steamship trying to get from one state to another? You have monopolies controlling how some of that works. And of course, you have people clashing over, in this case, a kind of travel. So this raises a question, is navigation included in the process of commerce? And so as one of the first cases dealing with interstate commerce, there are some things that come out of this case. First, the court finds that navigation is indeed included in commerce, right? It kind of makes sense when you think about it, that in order to get from one part of the country to another, you will need to cross some kind of either ocean, territory, and that includes navigating across it. That secondly, and this becomes important and will be important throughout the sort of evolution of the doctrine, the definition of among means that it is intermingled with. So imagine that something leaves a state, it enters interstate commerce, and it goes into another state. The boundaries are not that clear, so there has to be an intermingling around the boundaries of the state, which can include then the ways in which the federal government can regulate. And so the quote that's coming out of this case is that commerce among the states cannot stop at the external boundary line of each state, but may be introduced into the interior. So internal commerce is definitely reserved for the state under this original way of looking at it. So there is an intrastate kind of commerce that would not be implicated in any kind of federal legislation. But interstate commerce will have some mingling around the border. So I drew a picture for you. Here's my picture. I am clearly not an artist. Obviously the boat is going between states, and what you can see, oh good, I can make this work. The intermingling is sort of around the edges here. So as you go through interstate commerce and enter the other side, there will be a little bit of space here, conceptually, legally, where interstate commerce exists and where the federal government can regulate. So if we're looking at this as a whole, and of course states don't have this much space between most of them, but this is the place for federal regulation of interstate commerce under Gibbons versus Ogden. What's happening inside the state remains purely intrastate commerce. So that's sort of the starting point in terms of Gibbons versus Ogden. If you have any questions about this case or any of the others, go ahead and write them down as you're going through the different questions that emerge as we're going through this particular PowerPoint. And then we can use this as a way of going through the material a little bit. In fact, I have a question for you. The second question then are, what are the implications of Gibbons versus Ogden? The text suggests, of course, that this case helps establish that the constitutional foundation for interstate commerce, and it makes 4 points. I'll give you a hint. This all appears on page 406 to 407 of the book. So it's sort of the summary of the Gibbons versus Ogden case. And I would go through this, but I want you to look at this and write them down on your sheet and as part of what you'll be turning in as part of this assignment to make sure that you have watched this lecture, and we are already 9 minutes and 14 seconds into it. So this is a starting point, and now we have to figure out what exactly is in interstate commerce. And there's a lot of parts to this, right? As the United States has evolved over time, we've gone through a variety of different mechanisms of transportation. So some of the earlier ones were pretty rudimentary as the railroad system developed and steamships, etc. And as our industrial revolution occurred, it became more complex. And the railroad, of course, connected a variety of different parts of the country in ways that had never been done before. Additionally, as the economic situation changed and the Industrial Revolution began to expand the role of businesses, you saw that people began to find problems with the working conditions that were part of this sort of consolidation of business. So early economic changes in the United States included the consolidation of business into relatively large monopolies, right? And entire bodies of law have been developed to deal with those monopoly conditions. It also meant that working conditions were relatively poor, which necessitated, at least many people thought, necessitated the construction of labor laws, laws to deal with low wages, ways of dealing with sweatshop conditions, and all of these meant that people who were working under relatively bad conditions wanted to form labor unions and develop efforts to protect workers from the kinds of conditions they were experiencing on the job. As you can imagine, the people who owned the companies were not particularly excited about the idea of labor unions. Much of American history is a really fascinating investigation of how labor laws were fought and struggled for, and the massive levels of suppression that went into keeping them away. This, of course, has implications for interstate commerce, in part because, as I said earlier, if you want to regulate things like labor or wages or child labor or protection from people working in sweatshops, much of how you would do that is through the Interstate Commerce Clause. One of the earlier cases, and this is sort of an interim case before we get into United States versus E.C. Knight, is the case of the Shreveport rate case. And I'm not going into a lot of detail here. Again, I'm assuming that you've read this in the text so that you already have a sense of what it's about. But it established congressional power over the nation's railways, which was, of course, as you can see, a legal struggle. Nobody wants to be regulated, and this was one of the ways in which the United States federal government began to give some sense of national coherence to our transportation infrastructure. It also gave rise to what's called the Shreveport Doctrine. And that's the third question that I want you to answer is, what is the Shreveport Doctrine? In part, this becomes relatively important because it suggests that there's something more at stake here than simply interstate commerce, or the commerce of the ways in which things move in commerce. So keep that in mind and answer this question. Again, these questions won't take much more than a couple seconds to answer, I don't think, assuming that you can find them in the book. So the evolution of interstate commerce begins. We have a sort of baseline to start from, and now we're looking at how the case law helps develop it. One of the questions, of course, that comes out of that is this notion of manufacture and whether or not things that are manufactured are part of commerce. So if you own some kind of manufacturing plant, let's say you're making sweatshirts, these things are created in the plant, they're packaged, they're set on some kind of transportation vehicle. Early on, that might have been some kind of rail station, or probably today, it's a railroad or a truck or something like that. It's then put on the roads and shipped to wherever it may be. So the conventional understanding of interstate commerce would be the point at which that particular piece of good enters the flow of commerce. And that's something that we're going to be talking about in a lot of detail. United States versus E.C. Knight, as a case, begins to help us challenge or figure out what is meant and whether or not manufacture is part of commerce. Facts are pretty basic here. In America's Sugar's bid to buy 4 Pennsylvania sugar refineries, which would have included E.C. Knight, would have given them a 98% control of sugar refining in the United States, which is, for all intents and purposes, a monopoly. Now, as you all know, monopolies in economic terms aren't considered to be particularly healthy because it allows for them to fix prices at rates that are not competitive because there are no competition. There is no competition. At this point in time, the United States had the Sherman Antitrust Act, which was an effort to decrease monopoly power, and so this acquisition violated the Sherman Antitrust Act. American Sugar, of course, continued to want to acquire these, and they argued the law didn't apply because sugar refining was manufactured and controlled by the state. So it wasn't an issue of interstate commerce. It's a matter of manufacture. Therefore, it was an intrastate commerce, and the only people that could regulate it were states. So what was the outcome here? The outcome was that manufacture is not commerce, but comes before commerce. And therefore, this is a quote from the text, the regulation of commerce applies to the subjects of commerce and not to matters of internal police. And so one of the things this case helps to set up is the regulation of refining that it is an indirect impact on commerce and therefore not part of commerce. I'm going to stop here and we're going to start again in part 2 with this case because I'm running into my 15-minute barrier.